Why does Tanzania's ruling party keep winning elections? Is Tanzania's independent National Electoral Commission really independent? Why can't courts review presidential election results? Why is Tanzania still debating a new constitution after more than 30 years of multi-party politics? Millions of words have been written trying to answer these questions, but what if they all have the same answer? Because behind every election lies something much deeper than political parties. Institutions. And until we understand those institutions, Tanzania's elections will always seem confusing. Today, we go behind the ballot box. Consider the presidency. The Constitution describes the president as head of state, head of government, and commander-in-chief. Executive authority is vested in the president. The president appoints the prime minister, ministers and their secretaries, the attorney general, regional and district commissioners, ambassadors, and numerous senior state officials through constitutional and statutory processes. Under Tanzania's constitutional design, the presidency is not merely ceremonial, it is the center of the executive state. This structure had developed from the Republican Constitution of 1962. It was strengthened within the one-party political order, and it was consolidated under the 1977 Constitution. When multi-party politics returned in 1992, the presidency became electorally competitive. But the architecture of presidential power was not fundamentally redesigned. This created a new political reality. The president was now two things at the same time: the constitutional head of a powerful executive, and usually the national leader of a political party competing in elections. That is not unique to Tanzania. Presidents in many democracies are party leaders. The constitutional question is different. What institutions exist to balance executive power when the president is also an electoral competitor? Parliament, the courts, an independent electoral commission, local government, a free media? The strength of a multi-party system depends not only on whether opposition parties exist, it depends on whether institutions can operate independently when political interests collide. Now look at the institution running the entire game, the Independent National Electoral Commission, INEC. The name is brand new, the law is new. Some of the procedures are new. But what actually changed on the ground? Under the old system, the president directly appointed the commissioners. Local government directors, who report straight to the executive branch, automatically ran the elections locally. For decades, the opposition screamed foul. How can the referee be neutral when they are employed by one of the teams? So, in 2024, Tanzania passed a new law. It introduced a public application process for future commissioners. Vacancies are advertised, citizens apply, and a committee interviews them before handing names to the president. But here's the catch. The law also stated that the existing commissioners would simply stay in office until their terms expired. The name changed, the logo changed, but the leadership simply walked across the hall into the new building. Furthermore, those new interviews, they happen behind closed doors, completely hidden from the public eye. And it gets deeper. The 2024 reforms technically stopped local government directors from automatically acting as returning officers. INEC can now appoint its own. But in the 2025 elections, who did they choose? Senior public servants. The automatic link to local government was broken. The institutional link to the state administration remained completely intact. It leaves us with a simple, haunting question. How independent must a referee look before the losing side can trust the score? But there is an even deeper trap in the system. What happens if the presidential election itself is rigged? If a parliamentary seat is disputed, candidates go to court. Judges look at the evidence, hear arguments, and can overturn the result. But the presidency, that is a different world. Article 41, paragraph 7 of Tanzania's 1977 constitution contains an extraordinary sentence. Once the Electoral Commission declares a presidential winner, no domestic court in the land has the power to question it. Think about the weight of that. The most powerful office in the country is decided by voting. But the moment the winner is announced, the courthouse doors are locked. No recounts, no investigations into fraud. The declaration is final. Lawyers have fought this wall for decades. In 2020, the African Court on Human and People's Rights ruled in the landmark Jebra Kambole case that this rule directly violated the African Charter. The court ordered Tanzania to fix it. The state chose to leave the constitution untouched. Then, just months ago, in March 2026, the issue landed back at the African Court in Ado Shaibu versus Tanzania. Once again, the International Court found Article 41 fundamentally incompatible with human rights. Once again, Tanzania was ordered to amend its constitution. If the body declaring the winner is at the center of a fierce debate over its own independence, why is the presidency the one single office shielded from judicial scrutiny? Then came another constitutional dispute that exposed a legacy of one-party politics. Can a Tanzanian contest an election without belonging to a political party? The constitution guarantees political participation, but Tanzania's electoral framework requires candidates for the presidency and parliament to be sponsored by registered political parties. The Reverend Christopher Mtikila challenged this restriction. His argument was fundamental. If political participation is a constitutional right, why should a citizen be forced to join a political party before standing for public office? In 1993, Reverend Christopher Mtikila challenged the restriction before the High Court. In October 1994, the court found the prohibition on independent candidates constitutionally incompatible. The constitution was subsequently amended in a way that reinforced party-sponsored candidacy. Mtikila returned to court. The dispute continued for years. It eventually reached regional and African human rights institutions. The African Court on Human and People's Rights found Tanzania's prohibition of independent candidates inconsistent with protected political participation rights. Yet independent candidacy remained unresolved domestically. This was more than a dispute about one politician. It exposed a deeper constitutional question. Under one-party rule, political participation occurred through the party. After 1992, political participation occurred through parties. The number of parties changed, but the assumption that formal political competition must be channeled through political organizations remained. Again, change and continuity existed at the same time. Multi-party politics transformed Parliament. Opposition MPs finally entered the National Assembly, forcing ministers to answer tough questions on live television. Budgets were openly debated, but the architecture of the state still allowed the executive to quietly swallow the legislature. The president directly appoints the ministers, who then sit as lawmakers. The ruling party's majority dictates what laws pass, and party discipline ensures no one breaks ranks. For almost the entire multi-party era, CCM has held a crushing, absolute majority. There is a massive difference between what a constitution says on paper and how power works in reality. The law tells you what Parliament can do. Political power tells you what it is allowed to do. When one party controls the presidency, the ministries, and roughly 90% of the legislative seats, the separation of powers becomes an illusion. And it wasn't only Parliament living with that gap. Tanzania had introduced a Bill of Rights in the 1980s. The Constitution protected equality, personal liberty, freedom of expression, freedom of association, and the right to participate in public affairs. But constitutional rights operate alongside ordinary laws. Laws regulating newspapers, political organizations, and public assemblies remained on the books. The Constitution might protect freedom of expression, but Parliament could still enact laws regulating the media. The Constitution might protect assembly, but public order legislation still governed meetings and demonstrations. The key question became, when does regulation become restriction, and who decides? Increasingly, the answer was the courts. Tanzanian judges began hearing constitutional cases that tested the relationship between rights and state power. The judiciary became one of the arenas in which the unfinished transition was debated. But even here, another question emerged. What happens when a court challenges a political rule and Parliament simply changes the constitution? The Mtikila dispute had already provided one answer. In 1995, Tanzania held its first multi-party general election in nearly 30 years. Benjamin Mkapa of CCM won the presidency. Opposition parties entered parliament. Augustin Mrema emerged as a major challenger on the mainland. CUF became a major political force in Zanzibar. But the election also revealed problems that would become familiar. Administrative difficulties, disputes over electoral management, opposition mistrust, and severe controversy in Zanzibar. This was the first major test of the institutions inherited from the one-party state, because Tanzania's transition was about to face a problem common to dominant party systems. CCM was not an ordinary incumbent. It had governed since independence through TANU and later CCM. It possessed nationwide structures, historical legitimacy, experienced political cadres, and decades of organizational presence. Opposition parties were new. They needed offices, money, candidates, local networks, internal structures, and public recognition. Multi-party competition had begun, but the competitors had entered the race with very different histories. A level playing field could not be created simply by declaring the starting line open. As elections continued, the issues Nyalali had identified years earlier kept resurfacing. Presidential power, electoral independence, political freedoms, an unfinished constitution. Tanzania had answered the first question of the 1992 transition. Should opposition parties exist? But not the second. What constitutional system does genuine multi-party competition actually require? So in the 2000s, Tanzania tried again. By the 2000s, demands for constitutional reform were becoming increasingly difficult to ignore. Civil society organizations, opposition parties, legal scholars, and some political leaders argued that Tanzania needed more than constitutional amendments. It needed a new constitutional settlement. In 2011, President Jakaya Kikwete announced a constitutional review process. The government enacted the Constitutional Review Act, and a Constitutional Review Commission was established, chaired by former Prime Minister and former Attorney General Joseph Warioba. Once again, Tanzania went to the public. The commission collected views across the country. And once again, constitutional reform opened questions much deeper than elections. The union, presidential power, accountability, independent institutions, the electoral system, public leadership, the structure of government. The Commission produced a draft constitution, and one proposal transformed the entire debate. 3 governments: a union government, a government of Tanganyika, and a government of Zanzibar. For decades, Tanzania had operated with 2 governments: the union government and the revolutionary government of Zanzibar. The union government also administered non-union matters on the mainland. Warioba proposed changing that architecture, reopening one of Tanzania's oldest constitutional questions. What exactly is the union? The Warioba process had begun as a constitutional review. But constitutions determine political power, and political power is never merely technical. The proposed 3-government structure faced strong resistance from CCM. Supporters argued it could resolve long-standing tensions within the union. critics warned it could weaken, or even endanger, the union itself. The Constituent Assembly became deeply divided. Opposition parties and some civil society actors formed a coalition known as Mtikila, accusing the process of abandoning key recommendations from the Warioba draft. CCM defended a different constitutional vision. A proposed constitution eventually emerged from the Constituent Assembly, but the national referendum required to complete the process did not take place. The constitutional reform process stalled, and the 1977 constitution remained. This is one of the most important moments in Tanzania's modern political history. The country had spent years debating a new constitutional architecture. Millions of citizens had participated in consultations. A draft had been written, a constituent assembly had met. And yet, when the process ended, Tanzania returned to the same constitutional framework it had been debating how to replace. This does not mean Tanzania failed to democratize. That conclusion would be too simple. Opposition parties became legal. Competitive elections returned. The Bill of Rights gained real constitutional weight. Parliament became multi-party. Civil society and private media both expanded. Tanzania in 2015 was not Tanzania in 1985. But neither had the state been completely redesigned. The 1977 constitution remained. The executive presidency remained powerful. Candidates still needed a political party to stand. Electoral appointments stayed contested, and a declared presidential result remained beyond challenge in Tanzania's domestic courts. Regional administration stayed centralized. Constitutional reform stayed unfinished. This is why Tanzania's democratic transition is best understood not as an event, but as a process, one that began before 1992, continued after it, and kept returning to the same unresolved questions at the ballot box. Because once opposition parties grew stronger, the weaknesses of the system became harder to ignore. In 1995, the institutions faced their first major test. In 2000, Zanzibar exploded into political crisis. In 2010, a stronger mainland opposition emerged. In 2015, opposition parties partially united. By 2020, the relationship between state power and political competition had entered a far darker phase. In 2025, the country's leading opposition party was barred from the ballot outright, and the election that followed became the deadliest in Tanzania's history. 30 years. Different candidates, different presidents, different opposition leaders, but many of the same institutional controversies: electoral independence, candidate removal, media freedom, police powers, results transparency. Why? Perhaps because Tanzania had changed the players, without fully rebuilding the field. Behind every Tanzanian election, it was never just the parties on the ballot. It was the institutions standing behind them.